So basically, when you look at transnational litigation, you would want to start basically with looking at what kind of procedure you would like to go through: criminal law, civil law, or administrative law. And you would also need to look at possibilities of financing the case, because obviously you need sometimes these cases they take maybe 5 years or maybe 10 years. They can be quite extensive. And of course, it's also important to know if there's a big case to see what kind of proof there is, and if it's good enough to work with. Basically, you can then analyze and look at all sorts of possibilities that you can do, and you can identify the victims, which is also very important. You can litigate as an NGO. But you can also litigate directly with victims, which is the case with which we've done both, actually, in the case of Berta Cáceres, because her Indigenous organization wanted to be represented, but also the victims, the family of Berta Cáceres, was also prepared to go and take this case on. So another thing that you can do, because this bit is the civil part, but you can also go for administrative law. The thing with administrative law is that it would have to involve a Dutch state authority, right? So in this case, we have also done some administrative cases surrounding this case, getting to know, for example, banks around this, basically relationships with Honduran banks and the corrupt system that it had. So we could look a little bit more into that. And in the end, you can also look at a criminal complaint, and that's what we see here at number 7. And you can look at, well, obviously if there's a possibility for a criminal case, it would have to be against in general, it would have to be against the Dutch actor. So in this case, the FMO bank, the development bank, and that's also what we have actually done in this case. So we basically, sometimes you will look at going one of these roads, and we've done basically all of these roads in this case. So just to step back a little bit, there are some different cases in the Netherlands. Oh, sorry. There are different cases in Holland that are very much important and interesting to look at from this perspective of litigation, transnational litigation. In this case, we will be zooming in on some other case. So this is not about the Berta Cáceres case, but basically there's this other case in Holland, and it was against Shell, which is this big petroleum company that did also a lot of damages in Nigeria. And this is also, it looks like this is a very important case also to look at when you would want to go in and litigate in Holland, because this is a case where basically there was a lot of damage, a lot of people getting killed actually in this case, and it was all the subsidiaries of the Shell company, which is how it's very logically most of the time it's organized in this way. So basically the daughter companies, they were the ones that killed Nigerian people, and then the revolutionary bit about this case is that actually the mother company got put, they were responsibilized for this for these oil leakages and also for the killings. So this was one of the cases where you could see actually that you can if the mother company has enough knowledge and has enough involucramiento, enough involvement, then you can also go after the mother company. So that's quite an important case. Ron, you wanted to say something about this?
No, I just wanted to help you with the word influence. I saw you were searching for the word.
Okay, good. Yeah, so this is interesting to look at. It's one of the cases. There's also another very big case that's and this this was also very important in the case of the Berta Cáceres, because there's another case which is done by Milieudefensie, and it was for a climate case, and it was also against Shell, and it was about basically reaching the norm of 45% before 2030 as a norm within the climate cases, basically within the climate laws. And also the company got put responsible for actually reaching this norm, and so they also won this case against Shell. So it also shows that there is a due diligence responsibility for a company like Shell to reach climate goals. Is there until now a question in the audience, or maybe one that wants to say something?
I think there's a round of questions after the presentations.
Okay, that's true.
Maybe we can continue. Maybe just to add to this, the reason why these cases are so relevant is because these cases are relatively new. They're recent, and they are all based on the illicit act principle, combined with the due diligence norm, which in the case of Berta Cáceres was important because the bank, according to the victims, according to Copin and the children of Berta Cáceres, the bank FMO had an obligation towards the Lenca people, to do appropriate due diligence, which basically would have meant that if they had done good due diligence was to not fund the project, through which everything that happened could have been avoided, because the project heavily relied on financing from the banks. So these two cases are really important to sort of establish the violation of the norms, and it's hopefully it will really help us in the future in order to win the case also against FMO.
Yeah. So you already started a little bit with basically introducing the illicit act.
Sorry.
No, it's a good bridge. So basically, in the Dutch law, the basis for a civil complaint would be illicit act, and like just before, you could see in the jurisprudence and also in the norms in the Dutch law. You can go after a company, which is also not the case in every country, but in the Netherlands, that's definitely a possibility. But then you would have to go through a procedure of illicit act, and for that you need to meet the norms of the Article 162 of the Civil Code, and it means basically, and that will go in the next. In the next slides, you have to have accountability, causality, damages, and relativity. Those are the norms that need to be met for an illicit act. We don't need to go through it all very much, but it is good to see what an illicit act procedure looks like, and it's basically you need 4 elements. And these 4 elements, they have all their type. What is very important about the illicit act bit, illicit sounds like it has to be an infraction of a law, but that's actually not the case. Also, something that, according to habit, seems like inappropriate can actually also be a part of an illicit act. So. It also can be something that you don't do, as opposed to something that you do that is wrong and it causes damage. So the norm is actually, the bar is quite low for an illicit act if you consider the illegality of the act. Well, then you need to be responsible for the act, basically for the fault, and So that's and basically the author, so the company has to be responsible also for it. Then you have to have the damages, so you have to also show those damages. And even if you don't ask for the damages, sometimes you would want to go for an illicit act. You want to have an ideological pronunciation of a judge. But even if you don't ask for the damages, you still have to show for that the damages are there. And you don't have to show how much they are, but that there are damages. So that, and obviously, when you want to ask for high damages, you also have to prove them. So that's one of the things. Then there are a couple of elements that are a little bit less obvious. Causality, the damage needs to be caused exactly by the actions and the relativity. And this actually means that it also relates the norm that basically is being violated also should act as to protect also the person or the group of persons, the victims that is being protected. So that's a little bit how you can look at that, and then you can also apply them also to a certain case. In this case, we can apply them to the Berta Cáceres case, and then the most important bit about the Berta Cáceres case is, of course, that it's about due diligence. So it's about the bank. So this means also it's quite far away. So the people in general, they came by in the project in Honduras, but basically it's very important to show also that really the damage is caused by the company. So in this case, if the damage is being caused by the dam company, it doesn't mean that that you can attribute this damage to the bank necessarily. So you have to show why also the Dutch company has accountability for it. So also that would definitely also count in the case that there would be a case in Colombia. You would need to prove those sort of things. Ron, you have something more about this?
No, not really.
And I go on, I guess. What the things that are also the two procedures that are relating that are always important to see when you would go into Dutch law, and when you would look at how you can litigate a case, a transnational case. Basically, there are the possibilities for a short procedure. So if you want to solve something that basically needs to be solved tomorrow, you want to basically stop a company from doing something, then you would have to go for orden judicial, so a judicial order procedure, which is a short procedure, and it will not have a final say. It's basically a measure of order. So it's to stop the company from doing something on the basis of this illicit act, for example. You just say you have to stop polluting, for example, this lake, or you have to stop handling a certain way, or you have to stop paying. In the case of the Berta Cáceres case, it could have been that you could just say you have to stop giving out these loans because they actually create damages. They create people getting killed, violence happening. So that's what you can do. You can ask for a judicial order. It's actually not what is the part of this. This procedure was actually started after Berta Cáceres got killed. So it was an illicit act, but it was a procedure of declaration, basically asking for damages to be ordered on the basis of due diligence. So this was a long case. So that would be the longer case, so the declaration of law case. So those are two different article numbers that are there, but it basically shows the two ways: the long procedure and the short procedure. And the short procedure is basically a provisionary measure, an injunction. Do you have something on that, Ron? Maybe.
No, that's clear. Yeah, I think what's important to mention indeed, what you already said, that the procedure was actually started in 2018, which was 2 years after the killing of Berta Cáceres, and at that time, so in 2018, when the case was started, the project was already stopped. So it was already first paused, and later on in 2017, FMO had officially said, okay, we withdraw our funding. And it was only 1 year after that FMO withdrew its funding is when the summons was served against FMO. So that's also the reason why no short procedure applies in this case, because it was only decided to summon FMO in 2018 when the project was already over or stopped in any case.
Yeah, that's a very good addition. Thank you for that, Ron.
Wout,
yes.
Do you mind if you just wrap up, because we need to sort of move on?
Okay. Yeah. Basically, this is I have 2 minutes more. 1 minute more. Or I should stop.
1 minute.
1 minute. Okay. Basically, what we've also done, and that's there's also possibilities of criminal procedures. That's also what we've done. There are possibilities of accounting Dutch companies. That's here. There's a special team for international crimes, which is also very important. So I leave it at that to keep it short, but it just shows that we always also look at those kind of procedures. And basically one thing, and there's a lot of slides about this, but basically what I'm really proud of, that what we've reached in this procedure is they basically buried us with paperwork, and actually basically, and you can show that here, all of that, but we're not going to do that because there's no time. But what we've really reached, although this procedure has not ended yet, it's actually a very long procedure. But what we've reached is, because we studied the document so well, and also we looked at all the different things happening in Honduras, and also the WhatsApp messages. We could connect those WhatsApp messages with also the funding. So basically, in piles of paper, we found also the payments that were actually that actually were paid like 2 days before the murder of Berta Cáceres, and it actually came from a loan and went into this faulty not existing company. So that was something that we found, and it actually it's interesting because it didn't serve us that much for the civil case, but it served us a little bit more for the criminal complaint that we filed against FMO. But it also did a lot of work for the case in Honduras itself. So I think that's the part that I would say I'm most proud of, and that actually I can be proud of it, but actually it was Ron that found this. So I think Ron should be proud of this one. But yeah, that's to just wrap it up. Just so. I guess then we go straight away to preguntas. I think that was the last slide, but.
Thank you, Wout. Gracias. Vamos a pasar a la siguiente ponente. Teresa, can we just have you? And then maybe for 15 minutes, and then we can have some questions, yeah?
Sure. I will try to be brief as well. Let me just quickly pull up the my slides, which are here. Okay. Can you all see the slides? Okay.
I can.
Perfect. Also, I'm very sorry that I was thinking of making the slides in Spanish, but my Spanish, I wasn't confident enough to just do it without the help of my Spanish-speaking colleagues who are all on holidays or sick. So it is in English, but I will share it later, and then perhaps there is an opportunity to translate it. So I will focus this presentation on a certain type of laws that we think at ECCHR can be quite useful to address human rights violations vis-a-vis companies, especially in Europe, which are mandatory due diligence laws. And I will go into that in more detail now. So let me just briefly introduce my organization, which is the European Center for Constitutional and Human Rights. We are based in Berlin, in Germany, and we work closely with affected communities and partner organizations in countries all over the world to address international crimes, corporate human rights violations of migrants at the EU external borders, and the legacies of colonial crimes. So we have a wide range of cases that we work on. I personally work in the Business and Human Rights program, and there particularly with a focus on climate justice. Perhaps one thing to say is that we focus on using legal measures, but we try to be quite creative about the legal avenues that we take, sometimes because it is very difficult to find any. So we do cases in front of domestic courts. We use civil lawsuits, criminal complaints, administrative procedures, and we also sometimes bring cases before the European Court of Human Rights, or use the OECD complaint mechanism, which I think you will be discussing in a different session. And sometimes we engage with UN special procedures like the UN special rapporteurs, for example. And well, this time I will particularly talk about this one specific type of legal avenues, especially after Wout and Ron have already addressed a little bit the how bringing a civil lawsuit or also potentially a criminal lawsuit can play out. And just as a very short recap of the challenges of such procedures, which are unfortunately considerate, and which sometimes prevent us from advising to go that avenue and seek other avenues instead. One of them, for example, is that they are for civil lawsuits, and I would be very interested about to hear from you how you deal with that aspect, is high costs. Because in civil lawsuits, usually the plaintiff has to pay court costs, even though there is the possibility to apply for legal aid, but that is not guaranteed. Then there are costs of expert opinions, and there is the threat of having to pay the costs of the opponent if the case is lost. So this is that can be an obstacle to using a civil law avenue. Then another one that Wout has addressed in his presentation quite well is the matter to link the human rights violation to the parent company that is abroad, which there are ways, and in some jurisdictions there have been advancements in that regard, but it still remains a challenge. And then, of course, there's the matter of like a high standard of evidence, both in civil law and criminal law, that you have to really prove that responsibility of the parent company or sometimes of individual persons in the parent company for a human rights violation. And then another aspect is that procedures may take many years, sometimes decades, and there can be security risks involved because the persons bringing the complaint or the lawsuit might be quite exposed. So I don't say that a criminal complaint or a civil lawsuit is never an option, and I think sometimes it is the right way to go. But for this presentation, I just wanted to show that there is also that it sometimes makes sense to look at other alternatives that might have lower thresholds. So in particular, I will talk about so-called mandatory corporate due diligence laws, mechanisms. And these are laws that create specific legally binding obligations for companies headquartered, so for example, in European countries. One example is Germany. I will talk about that later. to exert due diligence with regard to their operations and that of companies along their supply chain. So that means that these companies have a specific obligation to have certain processes in place to identify risks of human rights violations and to take appropriate measures to prevent or remediate them in a quite broad scope, which is their own operations. That means the operations of the parent company, but also the operations of their subsidiaries, often abroad, and also their suppliers, so companies that they have merely contractual connections with, but that are not part of the company group. And yeah, okay, I had already started to translate some, so a little bit of Spanish might be found in the presentation. One law that I particularly want to talk about is the German supply chain due diligence law, which has entered into force or became applicable on the 1st of January 2023 with regard to companies of a certain size, which was 3,000 employees, and has since this year been also applicable to companies with 1,000 employees, that like companies that have this number of employees in Germany. And the main human rights risks that are covered by the law that the company has to focus on are labor rights, different sorts of labor rights, but also torture, killings, or interference with, for example, building trade unions by private or public security forces that are contracted or used by the company. And also environmental degradation that affects the human rights of people around. And finally, also unlawful evictions and deprivation of land as a means of livelihood, although it is not quite clear the extent of this obligation, in particular if it also applies to consultation rights of indigenous groups, the so-called right to free, prior and informed consent. So it is not clear simply because the law is not clear about it and there has been no, let's say, there have been no cases yet in that regard. And then it also covers certain environmental risks that the companies need to take into account. There are other human rights risks, but these are kind of the main ones. And the obligations of the companies in particular are that companies need to establish a risk management system that basically means that they have to integrate in all their operations and decision-making processes where they will collect information about possible human rights violations and systematically collect such information and also address these violations. Then the company also needs to analyze these human rights risks and whether such risks exist. And if it identifies such risks, it must take measures to prevent them. Or when human rights violations have already occurred or are ongoing, the company must take certain remedial measures. It is so these obligations are not always as strong as it sounds like. They're stronger when it comes to the company's own business operations, and that's of its subsidiaries, and those of its direct suppliers, but it becomes weaker when it is about indirect suppliers. And I will have a slide later to show that a bit more clearly. Another obligation that companies have is they must establish an internal complaint procedure that is accessible at all at all companies and also at the indirect suppliers. And there's also the obligation to have in place or the possibility to stay to keep the identity of the complainant confidential, which should address security risks. And throughout this whole process, like all these steps, that are outlined there, the company is obliged to engage in meaningful consultation with affected stakeholders. That means that the company needs to talk to its workers, it needs to talk to affected communities living in the area or that are affected by the operation directly. And here, well, you can see just roughly how broad the scope of the law is, which is, well, the parent company, the group companies, but also the direct suppliers and the indirect suppliers. So in theory, it is quite a broad scope. So the question is, how can you take action under this law, or how can you use it? So as I mentioned earlier, there is this, companies are obliged to have this internal complaint mechanism in place, which should enable persons to bring complaints, to bring attention to human rights violations to the parent company, which then triggers the responsibility of the parent company to do something about it to a certain extent. And if that is unsuccessful, there is the possibility to file a complaint with the competent German authority, which is responsible for supervising the implementation of this law. And finally, if this company does not act, there is the possibility of taking legal action before the German Administrative Court. Well, I mean, that, of course, like always, it sounds better than it probably is in practice. The law has been in place since 1.5 years, so we also can't really say how it will work out. We've been monitoring it closely at ECCHR, and also we brought some cases which are all still ongoing. But our experience so far is that companies are moving if confronted with such a complaint, and that also the German competent authority has been taking these complaints seriously so far. But no outcomes, or there are no cases that are completed yet. And a bit like in general, the advantages of this type of action is that there is a lower evidence threshold to trigger action, because you don't have to, it is really rather low to bring to the attention that there is possibility of human rights violations. And of course, the link between the subsidiary or the supplier and the parent company is already established by law. So it's kind of there, you can directly go to the parent company or address the parent company. It is cost-free, and there's potentially faster procedures as opposed to some civil or criminal cases that might go on for decades. And affected persons can have the possibility to actually have a say in the design of the remedies. So the competent authority should actually get in touch with the affected people and like try to get to an understanding what the company should do. But disadvantages is, of course, that the obligations of the companies are weaker. So it is just an obligation of efforts. That means the company has to do its best, but it does not have to really end the human rights violation in some cases. And that is, sometimes not very satisfactory. And also the remedies might be weaker in this case. Then just as an outlook, there is also a similar law has just been adopted by the European Parliament, which means that similar obligations to the ones that I just outlined will enter into force in all EU member countries from 2027, and then like according to or depending on the size of the company, 2028 and 2029. So not yet, but it is something to look out for. And finally, there is another new instrument which we at ECCHR find quite interesting. It is not, it will only start from 21st December 2024 to apply, but it is quite strict and also has quite a low threshold to engage authorities. And it concerns products that are made potentially by using or by causing deforestation. And this law it's the EU Deforestation Regulation that will also apply all over Europe or in all EU member states. And it requires that goods that are imported into the EU are deforestation-free and have been produced in accordance with the relevant legal provisions of the producing country, and are covered by due diligence declaration. But this is a particularly interesting aspect because it enables the importing country to ban a product when the product has been produced, or when in the production process, somewhere in the production process, there have been human rights violations, for example, because it was also contrary to the local law, like, for example, to Colombian law. That would be a ground to stop these imports. It concerns certain goods, which are listed here: cattle, cocoa, coffee, oil palm, soy, rubber, and woods. And it will apply for products. So it requires that products have been deforestation-free since 2021 or 2022. So quite a wide scope time-wise. And the obligations of companies here are, is again like conduct a risk assessment of the risk of deforestation or violation of local laws. Then they have to take measures to eliminate or reduce these risks. And this is quite strict. It is actually a stricter obligation than under the human rights due diligence laws, because here they are really allowed to import the product only when they declare there is no risk, or there's really, the risk is absolutely negligible. And they have to report on issue public reports about the risk assessment process, which includes a description of the process of consultation of indigenous peoples, of local communities, and other customary tenure rights holders, or of the civil society organizations that are present in the area of production of the relevant products. So that can already be a violation in that case if they simply report wrongly about these consultation processes. The enforcement is done again by authorities in the different EU member states, which can then suspend the import of products. They can demand the company to destroy or donate products. They can recall products, and they can impose penalties like financial sanctions or exclusion from public tenders. How to engage this this procedure is quite simple. It is that any legal or natural person, so not even a person that is personally affected, but it can be anyone, can bring a so-called substantiated concern to the relevant authority. And a substantiated concern is defined as duly reasoned claims based on objective and verifiable information. So it is quite low standard, actually. And here again, the advantages are that it has this quite low threshold to actually trigger action by the authorities. And again, the link to the EU company is already established by law. It is cost-free, and there's low security risks involved because there is this possibility, for example, to have a third party file the complaint. The disadvantages are clearer here because, so first of all, there's no engagement of stakeholders like affected communities envisaged in the procedure after the complaint has been filed. And there's also no remedies envisaged vis-a-vis those affected. So that means it is a procedure, it is a tool that is really only directed at the European authorities taking action against the company, but it is not about remedying those affected, which can be quite a disadvantage. But it is more about, so I just wanted to show this measure, this deforestation regulation, because it is some way to address an issue in the sense of putting pressure on the company, because this is both reputational risks that are involved here for a company if they are found to violate this deforestation regulation, and they will not be able to sell these products anymore on the European market, which might also hopefully lead to pressure to changes in their business practices. Yeah, that was just a very quick run through these type of due diligence measures, and I think there will be time for more questions now. Thank you for your attention.
Bueno, buenas tardes.
Good afternoon. My question is for both speakers. See which one can answer, or if you have a different concept of what I'm asking. At this point, the Colombian state is overwhelmed because of all these lawsuits, and it has lost some because of these mining multinationals. Some have taken advantage of the legislation, of the world legislation, of some international courts, which have lent themselves to cooperate with them. So what can we do, given this avalanche of lawsuits against the Colombian state for some actions that are being taken against all the illegal activity carried out in this country by some multinationals?
If I understood it correctly, basically what can be done against the Colombian state when all these transnational companies, when these companies are acting in Colombia, what can be done against the Colombian state? Well, to be honest, that's the part of the Colombian, that's the Colombian part. So that for transnationally, I mean, obviously you can come to me for advice and I can try and help you with it, but you would probably have to advise me because you know the Colombian law better than I do. And if you want to sue the Colombian state, you would have to do it in general in the Colombian court and not in the Dutch one, because also there will be immunity. So there's no possibility of going after a state in a court jurisdiction of another state. So because there would be immunity, that's very hard to do. But obviously, the transnational companies, you can go after them, and I think Theresa did a very good job in showing actually how the EU due diligence legislation works. So there are big chances there, big possibilities there. For big companies, that is. And also, I showed you when there is a Dutch company involved, there like companies like the Unilever, Shell, they all, in general have some subsidiary in the Netherlands. Those are possibilities, and basically it shows more that you can go to another state to sue those companies, but you can actually also sue them in general in your own state. In Colombia, you can also go after them, so it's not necessary always to go to this other state, but that is an option many times, and with all sorts of complications. But if I understood your question correctly, what can we do against the Colombian state? In the transnational way, it's very little. Against the companies, yes. And against Colombia, you would have to go to international gremia. I think Inter-American Court would be more of a possibility, possibly.
Sí, está usted hablando de tribunales de arbitraje.
So you talked about arbitration courts. Yes, that theme is different from these sessions, and we will be tackling the arbitration courts in a different session. So I think that it's best to leave that question for when we do that. Do we have any other question?
Gracias. Una
I have a question for Ron. No, Wout. Okay. If we want to use one of these suits that you have mentioned in the specific case of a multinational that has an affiliate in the Netherlands, do we need to go to a domestic legislation first before we start a lawsuit against the company there or not? And this is a question for Theresa. No, I lost the thread of my thought. I'm sorry.
I can respond to that. Maybe Ron, I think the last question I didn't fully get. So if you think I'm answering the wrong question, please interrupt. But if I understood it correctly, you're asking if you have to go through the Colombian system first before you can go to the Dutch system or the transnational route, and that's actually not the case. You don't have to do that. You can go directly if you meet all the standards, which are quite a lot of standards actually. But if you meet the standards and you have the finance and all these possibilities to go into this to another country, then you can. You don't have to wait. You don't have to go through a whole Colombian route. And that's different for international courts, because in the inter-American system you would have to finalize all the Colombian route, and also in the UN route you need to finalize everything in Colombia first. In the transnational bit, that's not the case.
Okay, gracias.
Thank you. And for Theresa, this is the question. In relation to your presentation, Theresa, when you told us that there is a lot of a veto for those, or ban for those products that may have been produced in violation of human rights, I have a concern, I have a question. Talking about the coal that is mined from the Department of CAJAR, where one of the multinationals even has a condemnation or has been condemned for financing the armed conflict. Would it be possible to ban the imports of those of the coal coming from this company? Because this company is definitely doing its mining in violation of human rights in our territory.
That is a very good question. And in fact, so it would not be, coal does not fall under the scope of the EU deforestation regulation. But in principle, it is something that one could generally consider and think about, like, depending on, like, I'm not familiar with the case, but if that if the coal itself is mined in violation of well, international law or domestic law, that would definitely fall under the EU human rights due diligence law, which is not in place yet. But it also depends where is the parent company incorporated? Is there a European parent company involved? United States. Yeah, well, unfortunately I'm not an expert on US law, but in general you would think that there must be some legal avenue to address that, but unfortunately it would depend on US law.
I'm proposing here that you write down any questions that have been left unanswered so that we can look for answers later on the clipboard. Any other questions?
Hola. Tengo dos preguntas.
I have two questions, but they have to do with the same case, actually, both of them. So first of all, how can we establish that a case is worthwhile, or that a case needs to be filed before foreign courts? Like, how can I know? How can I know, okay, this is not for the Colombian legal avenue. I think that this deserves being tackled by foreign courts. What's the true criterion that we should use there so as to take this extra step and take it to a court abroad? And I'm aware that this may be out of your framework of action, because I'm referring to Anglo-Gilashanti, the Indian multinational. But with this type of multinationals, where can I file a lawsuit? Anglo Gold Ashanti, she's referring to. The fact that Anglo Gold Ashanti does not operate in Colombia under the name Anglo Gold Ashanti, but through a relatively smaller company called Minera de Cobre Quebradona. So in this case, they operate under the name Minera de Cobre Quebradona. So I cannot accuse Anglo Gold Ashanti, which is the huge multinational that owns this project, as such. So do I have to start the case against the smaller company that acts here, or against Anglo Gold Ashanti? What do we do when the multinational does not operate under the name of the multinational, but through another company created here?
Hi, this is Avery Kelly from Corporate Accountability Law, the human rights NGO based in the US. I had a couple of questions about the EU deforestation regulation for tourism. And I realize it hasn't come into effect yet, so we may not know the answers to these questions yet. But I was curious if you know, Theresa, if the law applies to products that have then been incorporated into other products. For example, palm oil, as we know, is in so many different things. I'm wondering if the law will apply just to imports of palm oil itself or products that incorporate palm oil. And then my second question is, one thing I'm really excited about is to see that a possible penalty for violating the deforestation regulation would be blocking imports into the EU. I'm curious if you think that blocking imports sort of as a penalty for violations of the law may eventually appear in other frameworks, for example, the sustainability due diligence law in Germany or at the EU level.
I also wanted to make a comment to the peer here that had asked about mining operations in the Department of Cesar and whether there is jurisdiction on Drummond in Alabama. I'm a U.S. attorney, so we can discuss this later if you have questions.
Let's answer these questions, and then we can take two or three more.
Shall I maybe answer the first question raised about how to determine whether or not to start transnational litigation? I think that was the very first one, if I'm not wrong. I think it's a bit of a non-answer, but it really depends on the situation. It's really not a very helpful answer directly, but it really depends on the involvement of the multinational company. So, for example, if there is a ultimate mother company based in the Netherlands on Dutch territory that has a subsidiary who has a subsidiary that is active, for example, in Colombia, but the Dutch company, for example, only has a mailbox in the Netherlands, is just used for tax benefits, etc., but doesn't have anything to do with the operational part that leading to the human rights violation, then it can prove to be very difficult to go to the Dutch territory. It doesn't mean that it's impossible, but in circumstances like that, where there is no real direct link between the human rights violation and the multinational company based in the Netherlands, then it might be worth focusing your efforts on other avenues instead of going through the Dutch legal system. On the other hand, if there is, and we use again the example of the Shell case in Nigeria, where the link between Shell Netherlands and Shell Nigeria was quite direct, and it was easy to prove, or not easy, but it was possible to prove that Shell Netherlands had sufficient control over Shell Nigeria, then it might be worth to really to really examine this possibility to go to the Dutch court or to another court in Europe. So I think maybe it's not a very satisfying answer, but the answer is really you need to look at all the elements of the specific case in order to come with an answer, in my view.
Quería comentar que vamos a tener
We
una
are going to
sesión.
have a session in the upcoming days as to how to analyze the structures and the financial flows of the companies. This will be done by a Dutch organization, so no. And it's very important because it will give us many clues as to the legal strategy and the legal avenues that could be available for that. Because of what Ron says, in fact, every case is different and specific. An analysis must be made of the situation, the subsidiaries, the nationalities, the structures, the national flows, and that will give us some information. But we will have a session exactly on that, exactly on how to do
That's,
that.
by the way, that's a great tool, the SOMO tool. We've used it several times already. It's really good.
The
Thanks,
counter.
Susie.
Yes, exactly.
Yeah.
The counter. Vamos a conocerles. Muy bien. ¿Podemos tomar un par de preguntas más?
Maybe Teresa, the question about the deforestation. I think that was a question for you.
Yes. And perhaps also just to add to what you said, Ron, earlier, and the question how to decide on what to use. I just want to add on my presentation that actually I think the tools that I presented are quite useful also to engage without much effort. So it is something that we would advise in many cases to go for that avenue also in parallel to other steps, be it national litigation or transnational litigation. But with regard to the question of the EU deforestation regulation, sorry, I remember the part of the question where you asked whether it is feasible that this is something that or could eventually come with regard to other products as well, that like something that would lead to an import ban, which is, well, I mean, with the new composition of the European Parliament right at the moment, there's not much hope for any progressive legislation, unfortunately. But in general, it is something that is generally feasible, and it will probably also depend on the development of the deforestation regulation and the implementation of that, and how it works in practice, and whether it can serve as a model to other such forms of legislation. There is actually something similar, which is called the conflict minerals regulation, which concerns, like as the name says, minerals that are produced in conflict-affected areas, certain types of minerals. I'm not so familiar with that regulation, so I cannot tell you for sure how it works. But as far as my knowledge goes, is that it also puts certain restrictions on import. But could you remind me of the first part of your question, please?
Sorry, thanks, Theresa. Yeah, my question was, do you know if the law applies to products that integrate like cocoa or coffee or palm oil, or if it's just to the pure products that would be entering the EU?
Right. Yes. So that regulation also applies to products that are made of these raw materials. So it is quite broad in that sense.
Bueno, mi pregunta es para el compañero Wout.
My question is for Wout. Since we have been working for some time now with the multinational Aguas de Barcelona in the marshland area of Guangdong, my question for Wout is, what is being done? And as we heard here before, sometimes for these communities, well, we don't have the resources to do those things. These organizations, well, we look for these organizations for help. And we agreed on certain verbal agreements the other time, but I'm going to ask this in front of all the people here. How are we doing? because we're in despair with Aguas de Cartagena here, because the communities that live around that marshland have been left with nothing. We're waiting for help so that this process with Aguas de Barcelona can start right now, because if we have to wait for a long time, if we have to wait more, we're going to die. We're going to run out of territory. That's my question.
I can respond only on behalf of Eileen. He's part of, but he is the one that leads the case. And it's not easy. The case is not easy. And I don't think we have a lawyer in Spain. So when we have a case like this, it's going to be a lot easier, but I can't do anything in here in the Netherlands. There isn't a headquarters or a subsidiary company, so we can't do this transnational litigation from the Dutch republics. So it's something harsh to say, but I can litigate in Holland, but not in Spain. Maybe with new laws, there might be the possibility to litigate with due diligence, but that's going to take a longer time, and it will take. I don't know whether the people from Barcelona, I don't know whether they have 3,000 employees, so I don't really know whether there's a possibility already to really sue them. So the possibility of doing something in Spain is something that you should analyze, but we can't do it from the Netherlands. You need to talk to Avril. I'm going to Roots to Justice. Our organization, we are working with ADIL to look for lawyers in Spain or Spanish lawyers that to help with litigation, but we can't litigate in the Netherlands. But I will give the phone to Adil, so see if he wants to say something. Good morning, Wout. Greetings to you, Ron. My greetings from Wout. You're absolutely right. We have had, for many years we've been waiting that from Spain they could support us to conduct some highly qualified studies to be able to determine the environmental damage and the damage to living, especially human rights violations in addition to other. But after 5 years, that I don't want to say the name, we feel that they did not, they distracted us, because after 5 years we haven't been able to move forward with that study. And without the study or this investigation, we can't think about a case, because these companies, they invest a lot in communication media and they bribe. And that's what I've heard also in Spain, that they bribe. So right now, we are enabling the conditions, finding some strategic partners in Spain, but we're also trying to find universities or non-profit organizations that may support some studies to really analyze to have the impact studies on the damage to the environment, to human rights, and to be able to sue this in Spanish court. So you are right, because you are in the Netherlands. Well, the Dutch companies, they support the extraction of coal, but also the buying of palm. But this is a Spanish company with their parent company in France. So the parent company is in Spain. They have the main company is in Spain, and subsidiaries. One of those is Aguas de Cartagena, which is in Colombia. We have one more question and then we will go into the next session, which is related to United Nations. So how we can have access to other courts in the United Nations. I have a question for Wout. At the beginning you said that here our friend from La Guajira said that in the Colombian state they lose so many lawsuits, and you said that all those lawsuits against the Colombian state should be the one that should be responsible for them. But I would like to know, when these lawsuits involve other countries in terms of policies that apply here in Colombia, for example, the anti-drug policy, how much time should we give the Colombian state to respond to a lawsuit when we've been affected because of the law against the drug? And where can we also file a claim internationally, because this has affected other countries and many Colombian families? So, as you all know, is there some time for the court to respond to us? And if that policy, which involves other countries, where can we file the claim? And who would be the entity receiving? When this is another way of tackling internal possibilities. So maybe you could go to Inter-American Court for Human Rights. So there you have the possibility of litigation, not transnational but international litigation. So that's the possibility to have international litigation. You have to go to a court for human rights, but there isn't a specific time. It's something that the court should decide. The time or it's not stated. I don't know anything about Colombian law, and let alone Inter-American law, but it's the jurisprudence of the Inter-American Court that really decides what is the appropriate timing, or the time after where they can leave the case in the hands of the state, and it will go to the Inter-American Court. I know it's not the best answer, but those are the laws and the jurisprudence that really decides what's the time that they need, and after this specific time it would go to the Inter-American Court or the Regional Court of Human Rights. Thank you, Wout. Would somebody like to ask another question? Or there was another part of the question on a lot of lawsuits against Colombia due to arbitration tribunals. That's something really big. There are so many arbitrations, and then when they relate to human rights, and so because there's a large company and they lose their permits, and then the large company, they litigate against the state. That is also an issue that we acknowledged and that we have recognized in the international arena, and there are many cases that we have to fight this. It's not a solution, but it's a very well-known issue, and we need to fight against those types of agreements or that really favor the companies. Thank you, Wout. Thank you, Ronnie and Teresa. Gracias por sus aportes. Vamos a seguir adelante con la siguiente sesión. arbitration tribunals. We know that it is an important issue in the Colombian context. We will touch on this in the forum, but if the participants would like to have more debate on this topic, but we as Roots to Justice, we could organize a roundtable with international experts only on that topic, just so you bear this in mind. So we will now give the floor to the next speaker, Santiago from CAJAR, who is going to talk to us about what would be the options that you would have in the event you would like to raise a claim before the United Nations. So this forum really is about giving you options. Sometimes the options, sometimes you might take a lot of these options and some with in collaboration with. We want you to keep your mind open so you can see all the possible options. Maybe it's a wide range of opportunities and options, and so you just can't just use one of those.
Unfortunately, I have to go, so I just want to thank you and say goodbye, and also thank you for the great translation. And good luck for the next days.
Us too.
Thanks, Teresa. It was nice to meet you.
Thank you.
Same here.
Muchas gracias. Thank you so much.
Bye-bye.
Bye-bye.